Good evening, all. Christ College Irinjalakuda is very happy to welcome you all to the one-day international webinar on IPR, Protecting Your Ideas, organized by Department of Physics in association with Internal Quality Assurance Cell, Christ College Irinjalakuda. We have with us Dr. Shahina Abdullah, IP consultant, Tatasteel Europe, Netherlands, as our resource person of the day. Also, we are proud enough to have our own alumni as our resource person of the day. So without much delay, let's officially begin our program. I'm very happy to invite Dr. Shaju KY, Vice Principal, Christ College Irinjalakuda, and Head of the Department of Physics for welcome address. Shaju sir.
ഓക്കെ, താങ്ക് യു. എത്രയും സ്നേഹം നിറഞ്ഞ അധ്യാപകരെ, വിദ്യാർത്ഥികളെ, എല്ലാവർക്കും നല്ലൊരു ദിവസത്തിന്റെ അവസാനം 1 മണിക്കൂർ ആശംസിക്കുന്നു. സ്വാഗതം പറയാന്നുള്ള എൻ്റെ ചടങ്ങിലേക്ക് ഞാൻ നേരിട്ട് കടക്കുകയാണ്. നമുക്ക് അധികം ഫോർമാലിറ്റി ആവശ്യമില്ല, കാരണം നമ്മുടെ തന്നെ അലുമിനി ആയിട്ടുള്ള ഷാഹിനിയാണ് നമ്മുടെ റിസോഴ്സ് പേഴ്സൺ. അതുകൊണ്ട് തന്നെ നമുക്ക് അധികം ഫോർമാലിറ്റിയുടെ ആവശ്യമില്ല. പുറത്തുനിന്ന് അധികം ആൾക്കാരില്ല എന്ന് തോന്നുന്നു. എന്തായാലും നമ്മുടെ ബഹുമാനപ്പെട്ട ജോളിച്ചൻ, എല്ലാവർക്കും പ്രിയങ്കരനായ ജോളിച്ചൻ, നമ്മുടെ കോളേജിനെ അനുദിനം മുന്നോട്ട് നയിക്കാനായിട്ട് കഠിന പരിശ്രമം നടത്തുന്ന ജോളിച്ചൻ നമ്മുടെ ഇന്ന് മീറ്റിങ്ങിൽ അധ്യക്ഷനായിട്ടുണ്ട്. എൻ്റെ വെൽക്കം സ്പീച്ച് കഴിഞ്ഞാൽ ജോളിച്ചൻ അധ്യക്ഷ പ്രസംഗം നടത്തുന്നതായിരിക്കും. എന്തായാലും ജോളിച്ചൻ്റെ എല്ലാ കാര്യങ്ങൾക്കും നമ്മളെല്ലാവരും ഒറ്റക്കെട്ടായിട്ട് തന്നെ ജോളിച്ചൻ്റെ കൂടെ ഉണ്ട്. കോളേജിനെ നമുക്കൊരു പുതിയ തലത്തിലെത്തിക്കണം. അത്തരത്തിലൊരു വിഷയമാണ് നമ്മൾ ഇന്ന് തിരഞ്ഞെടുത്തിട്ടുള്ളത്. നാക്കും എല്ലാവരും ഇതിന് വളരെയധികം ഇമ്പോർട്ടൻസ് കൊടുക്കുന്നുണ്ടെന്ന് നമുക്ക് മനസ്സിലായി. അതിനാലാണ് നമ്മൾ IQAC ആണ് നടത്തുന്നത്. നമ്മൾ ഫിസിക്സ് അതിൻ്റെ കൂടെ നമ്മൾ ജോയിൻ ചെയ്തതെന്ന് മാത്രമേ ഉള്ളൂ. അപ്പോൾ ജോലിച്ചിന് നമ്മുടെ ഇവിടെ കൂടിയിരിക്കുന്ന എല്ലാവരുടെയും പേരിൽ ഞാൻ എത്രയും സ്നേഹപൂർവമായ സ്വാഗതം ആശംസിക്കുന്നു. അടുത്തതായി നമ്മുടെ റിസോഴ്സ് പേഴ്സൺ ആണ് ഡോക്ടർ ഷാഹിന. ഷാഹിന ഇപ്പോൾ ഓൾറെഡി എല്ലാവരും കേട്ടിട്ടുണ്ടാവും. നമ്മൾ ഓൾറെഡി മീറ്റിങ്ങിൽ സംസാരിച്ചു. 2004 ഇവിടുന്ന് MSc ഫിസിക്സ് പാസ്സായിട്ട് അന്ന് തന്നെ ഷാഹിന ഒരു വളരെ അംബീഷ്യസ് ആയിട്ടുള്ള സ്റ്റുഡൻ്റ് ആയിരുന്നു. ഞാൻ ഓർക്കുന്നുണ്ട്. ആള് ഒന്നും സാറ്റിസ്ഫൈഡ് അല്ലാത്ത, എനിക്ക് റിസർച്ച് ചെയ്യണം, അത് വേണം, എന്നെ ഒരുപാട് ആഗ്രഹങ്ങൾ, സ്വപ്നങ്ങളൊക്കെ ആയിട്ട് ഇങ്ങനെ ഓടി നടന്നിരുന്ന ഷാഹിന ഉദ്ദേശിച്ച രീതിയിൽ തന്നെ സ്ഥലത്ത് നല്ലൊരു രീതിയിൽ എത്തിപ്പെട്ടു എന്നുള്ളത് വളരെ സന്തോഷം നൽകുന്ന കാര്യമാണ്. അപ്പൊ അത് ഞങ്ങൾ ഒരുപക്ഷെ എല്ലാവരെയും ഒരുപോലെയാണ് നമ്മൾ പഠിപ്പിക്കുക. അപ്പൊ നമ്മൾ ആലോചിക്കും, നമ്മുടെ കുഴപ്പമാണോ അത് കുട്ടികളുടെ കുഴപ്പമാണോ, എന്തുകൊണ്ടാണ് ഈ കുട്ടികൾ നല്ല രീതിയിൽ എത്താത്തതെന്ന് നമ്മളിങ്ങനെ ആലോചിക്കും. അപ്പോൾ അതിനൊരു നല്ലൊരു ഉദാഹരണമാണ് ഷാഹിന. ഷാഹിനയ്ക്ക് വേണ്ടി നമ്മൾ പ്രത്യേകമായിട്ടൊന്നും ചെയ്തിട്ടില്ല, എല്ലാവരും ചെയ്ത പോലെ തന്നെ നമ്മളും ചെയ്തിട്ടുള്ളൂ. പക്ഷെ ചില കുട്ടികൾ എക്സൽ ചെയ്യാനായിട്ട് ആഗ്രഹിക്കും, അവരതിനു വേണ്ടി കഠിന പരിശ്രമം നടത്തും, അവർ വിജയിക്കും. അതാണ് ഇപ്പൊ അതിനൊരു ബെസ്റ്റ് എക്സാമ്പിൾ ആണ് ഷാഹിന. ഷാഹിന ഇവിടെ നിന്ന് MSc കഴിഞ്ഞിട്ട് മറ്റേ ISROയിൽ പ്രോജക്റ്റ് ട്രെയിനി ആയിട്ട് പോയി. അവിടെ 1-2 നല്ല പ്രോജക്ട്സ് ഒക്കെ ചെയ്തു. അതിനുശേഷം അവിടെ ഇരിക്കുമ്പോഴാണ് നെതർലാൻഡ്സിലേക്ക് PhDക്ക് വേണ്ടി അപ്ലൈ ചെയ്യും. അവിടെ പ്രവേശനം കിട്ടും. പിന്നെ അവിടെ ഒരിക്കൽ കടന്നു കഴിഞ്ഞാൽ പിന്നെ ആ റൂട്ടിൽ അങ്ങോട്ട് പൊക്കോളും. അപ്പൊ അവിടെ ആദ്യത്തെ ഒരു ബാരിയർ അങ്ങോട്ട് കടന്നു കിട്ടാനേ മാത്രമേ ബുദ്ധിമുട്ടുള്ളൂ. ആ ബാരിയർ ഷാഹിന വളരെ ഈസി ആയിട്ട് തരണം ചെയ്തു. അങ്ങനെ അതിന് നമുക്ക് സൈറ്റ് ചെയ്യാവുന്ന ഒരു എക്സാമ്പിൾ ആണത്. മാത്രമല്ല നല്ല രീതിയിൽ PhD ഗവേഷണം പൂർത്തിയാക്കി. ഞാൻ ഷാഹിനയുടെ ബയോഡാറ്റ ഒക്കെ നോക്കി, നല്ല ലിങ്ക്ഡിനിലൊക്കെ നല്ല രീതിയിൽ പെർഫോം ചെയ്തിട്ടുണ്ട്. പിന്നെ ഇപ്പൊ IP കൺസൾട്ടന്റ് ആയിട്ട് IPR ടാറ്റ, അതെനിക്ക് മനസ്സിലായില്ല, ഇന്ത്യയുടെ അവിടെ കമ്പനി ഉണ്ടോയെന്നൊന്നും എനിക്ക് അറിഞ്ഞുകൂടാ. എല്ലാം വിശദമായിട്ട് ഷാഹിന തന്നെ പറഞ്ഞുതരും. എന്തായാലും ഇതൊരു പുതിയ വിഷയമാണ്. എനിക്ക് അതിനെപ്പറ്റി കാര്യമായിട്ട് അറിയില്ല. ഞാൻ കൊച്ചിൻ യൂണിവേഴ്സിറ്റിയിൽ പഠിക്കണ PhD ചെയ്യുന്ന സമയത്ത് ഇതിന്റെ 1-2 ടോക്കിനൊക്കെ അന്ന് അവിടെ നടക്കുമ്പോൾ കേട്ടിട്ടുണ്ട്. ഒരു 10 കൊല്ലം മുമ്പ് തന്നെ അവിടെ ഇതിന്റെ പറ്റിയിട്ടൊക്കെ ഇങ്ങനെ ചെറിയ ചെറിയ ടോക്കുകളൊക്കെ ഞാൻ കേട്ടിട്ടുണ്ട് എന്നല്ലാതെ ഇങ്ങനെ പേറ്റന്റിനെ കുറിച്ചിട്ടോ അല്ലെങ്കിൽ കോപ്പിറൈറ്റ്സ് കുറിച്ചിട്ടോ അങ്ങനെയുള്ള അധിക കാര്യങ്ങളൊന്നും നമുക്ക് അറിഞ്ഞുകൂടാ. കാരണം നമ്മൾ അങ്ങനത്തെ ഫീൽഡിൽ അധികം വർക്ക് ചെയ്യാറില്ല. മാത്രമല്ല ഞാനിപ്പോ ആകെ ചെയ്യേണ്ടത്, എന്റെ പേഴ്സണലായിട്ട് ഞാൻ പറയുകയാണെങ്കിൽ, ഞാൻ ഒരു ബുക്ക് എഴുതുന്നുണ്ട്. അപ്പൊ ബുക്ക് എഴുതുമ്പോൾ തന്നെ എന്താണ് ഇതിലൊക്കെ ശ്രദ്ധിക്കേണ്ടത്, കോപ്പി വേറെ ആൾക്കാരുടെ നമ്മൾ കോപ്പി അടിച്ചു എന്ന് പരാതി വരും, അങ്ങനെയൊക്കെയുള്ള പേടിയുണ്ട് നമുക്ക്. അത്രേ ഉള്ളൂ. എനിക്കൊക്കെ അങ്ങനെ ഒരു അക്കാഡമിക് ലെവൽ മാത്രമേ ഉള്ളൂ. അപ്പൊ എന്തായാലും ഷാഹിന എന്ന് നമ്മളോട് സംസാരിക്കാൻ എത്തിയിട്ടുണ്ട്. ഷാഹിനെ ഞാൻ നമ്മുടെ എല്ലാവരുടെയും പേരിൽ സ്വാഗതം ചെയ്യുന്നു.
താങ്ക് യു.
അടുത്തതായി നമ്മുടെ IQAC കോർഡിനേറ്റർ റോബിൻസ് സാറ്, നമുക്ക് അറിയാവുന്ന പോലെ വളരെയധികം ഹാർഡ് വർക്ക് ചെയ്ത് കോളേജിനെ വളരെ നല്ല രീതിയിൽ മുന്നോട്ട് നയിക്കാൻ, നല്ലൊരു ലെവലിൽ എത്തിക്കാൻ വേണ്ടി രാവും പകലും കഷ്ടപ്പെടുന്ന റോബിൻസ് സാറ്, സാറിനെ ഞാൻ എല്ലാവരുടെയും പേരിൽ പ്രത്യേകം സ്വാഗതം ആശംസിക്കുന്നു. ഇനി ഞാൻ അധികം സമയം എടുക്കുന്നില്ല. ഇന്ന് കമ്പയർ ചെയ്യുന്ന ജീൻ മരിയ ടീച്ചർ, എക്കണോമിക്സ് ഡിപ്പാർട്ട്മെന്റിൽ, ഹോസ്റ്റ് എഡ്വിൻ സാറ്, ഞങ്ങളുടെ ഫിസിക്സിൽ തന്നെയുള്ള എഡ്വിൻ സാറ്, ബാക്കിയുള്ള എല്ലാ ടീച്ചേഴ്സും, കോളേജിലുള്ള ഒരുപാട് ടീച്ചേഴ്സ് പങ്കെടുക്കുന്നുണ്ട്. എല്ലാവരും ഞാൻ ഒറ്റ വാക്കിൽ സ്വാഗതം ആശംസിച്ചുകൊണ്ട് നിങ്ങൾക്ക് നല്ലൊരു ശുഭരാത്രി നേരുന്നില്ല, ഒരു ഈവനിങ്, നല്ലൊരു ഈവനിങ് നേർന്നുകൊണ്ട് നല്ലൊരു സെഷൻ ആയിരിക്കും എന്ന് എനിക്ക് ഉറപ്പുണ്ട്. കാരണം ഷാഹിന അതിൽ നല്ലൊരു എക്സ്പെർട്ട് തന്നെയാണ് ഈ വക കാര്യത്തിൽ. അല്ലാണ്ട് ഇങ്ങനെ അവിടെ ടാറ്റ കമ്പനിയോ അല്ലെങ്കിൽ അവിടെയൊന്നും ഷാഹിനെ ജോലിക്ക് എടുക്കില്ല. അപ്പൊ നമുക്ക് നമുക്ക് ഷാഹിനയുടെ ടോക്കിന് ശ്രദ്ധിച്ചിട്ട് പിന്നെ സെക്കൻഡ് സെഷനിൽ ഡിസ്കഷനിൽ ആയിട്ട് പങ്കെടുക്കാമെന്നാണ് ഷാഹിന പറഞ്ഞിട്ടുള്ളത്. ഓക്കെ, അപ്പൊ എല്ലാവർക്കും ഞാൻ ഒറ്റ വാക്കിൽ ഒരിക്കൽ കൂടെ സ്വാഗതം ആശംസിച്ചുകൊണ്ട്, വിദ്യാർത്ഥികൾ ഉണ്ടെങ്കിൽ അവർക്കും സ്നേഹപൂർവ്വം സ്വാഗതം ആശംസിച്ചുകൊണ്ട് നിർത്തുന്നു. നന്ദി, നമസ്കാരം. താങ്ക് യു.
Thank you, Shaji sir. Now I invite Reverend Dr. Jolly Andrew CMI, Principal, Christ College Irinjalakuda, for inaugural address. Father.
Okay. എന്നെ കാണാനും കേൾക്കാനും പറ്റുന്നില്ലേ?
പറ്റുന്നുണ്ട്.
ഓക്കെ, താങ്ക് യു. ഇന്നത്തെ റിസോഴ്സ് പേഴ്സൺ ഡോക്ടർ ഷാഹിന അബ്ദുള്ള, IP കൺസൾട്ടന്റ്, Tatasteel യൂറോപ്പ് ഫ്രം നെതർലൻഡ്സ്. ഇന്ന് സ്വാഗതം ആശംസിച്ച കലാലയത്തിൻ്റെ വൈസ് പ്രിൻസിപ്പളും കൂടിയായ ഡോക്ടർ KY ഷാജി സാർ, മറ്റു വൈസ് പ്രിൻസിപ്പൽസ്, ഡീൻമാർ, പ്രിയമുള്ള അധ്യാപകർ, റിസർച്ച് ഗൈഡ്സ്, റിസർച്ച് സ്റ്റുഡൻസ്, PG സ്റ്റുഡൻസ്, ഈ കലാലയത്തിന് പുറത്തുമുള്ള പ്രിയമുള്ള അധ്യാപകരും വിദ്യാർത്ഥികളുമായിട്ടുള്ളവരെ, ഇന്ന് വളരെ പുതുമയാർന്നൊരു വിഷയം ഇന്ന് നമ്മളോട് സംസാരിക്കുകയാണ് ഡോക്ടർ ഷാഹിന അബ്ദുള്ള. ഷാഹിന ഇന്ന് നമ്മളോട് സംസാരിക്കുന്ന വിഷയം പ്രൊട്ടക്റ്റിംഗ് യുവർ ഐഡിയാസ്, IPR. പാറ്റന്റുകളെ കുറിച്ച് നമുക്ക് എല്ലാവർക്കും അറിയാം. നമ്മുടെ ആശയങ്ങൾ, നമ്മൾ ചെയ്തിട്ടുള്ള കാര്യങ്ങൾ, ഇതെല്ലാം നമുക്ക് ലഭിക്കുന്ന, നമ്മളുടേതാണ് എന്ന് പറഞ്ഞ് നമുക്ക് ലഭിക്കുന്ന അവകാശമാണ് പാറ്റന്റുകൾ. ഈ പാറ്റന്റുകൾ അതിൻ്റേതായിട്ടൊരു പ്രോസസ്സിലൂടെ കടന്നു പോയാലാണ് ആ പാറ്റന്റുകൾ നമുക്ക് ലഭിക്കുക എന്ന് നമുക്കറിയാം. ഇന്ന് നമ്മുടെ ആശയങ്ങൾ നമ്മുടേതായി എങ്ങനെ സംരക്ഷിക്കണം എന്നുള്ള വിഷയത്തെക്കുറിച്ച് ഡോക്ടർ ഷാഹിന നമ്മളോട് സംസാരിക്കുകയാണ്. ഏതാനും മണിക്കൂറുകൾക്ക് മുമ്പ് ക്രൈസ്റ്റ് കോളേജ് ഇന്നൊവേഷൻ കൗൺസിലിലെ ഡോക്ടർ ഷാഹിന മെമ്പറാണ്. അതിൽ ജോയിൻ ചെയ്തിരുന്നു, നെതർലൻഡ്സിൽ ജോയിൻ ചെയ്തിരുന്നു. വളരെ ഫ്രൂട്ട്ഫുള്ളായിട്ടൊരു ഡിസ്കഷൻ, വ്യത്യസ്തരായ ഇൻഡസ്ട്രിയലിസ്റ്റും അതുപോലെ തന്നെ ഓൺട്രപ്രണർഷിപ്പ് ആരംഭിച്ചിട്ടുള്ളവർ, പുതിയ ഇൻക്യുബേഷൻ, ആ ചിന്തകളുമൊക്കെ പങ്കുവെക്കുന്ന ഒത്തിരിയേറെ പേര് നമ്മളുമായിട്ട് ആശയങ്ങൾ ഇന്ന് പങ്കുവെക്കുകയുണ്ടായി. അതിൽ നമുക്ക് മനസ്സിലായിട്ടുള്ളൊരു ആശയം, ഇന്നത്തെ ഉന്നത വിദ്യാഭ്യാസം UGC അടക്കം നിഷ്കർഷിക്കുന്നത് ഈ തരത്തിലുള്ള ആശയങ്ങൾ കൊണ്ടുവരാനും ലോകത്തിനാവശ്യമായിട്ടുള്ള ഈ ആശയങ്ങൾ അത് വേണ്ട രീതിയിൽ പബ്ലിഷ് ചെയ്യാനും പാറ്റന്റ് എടുക്കാൻ നമ്മൾ ശ്രദ്ധിക്കണമെന്നുള്ളതാണ്. അപ്പം അതിനെക്കുറിച്ച് ഇന്ന് നമ്മളോട് സംസാരിക്കുന്ന ഡോക്ടർ ഷാഹിന അബ്ദുള്ളയാണ്. എനിക്ക് വലിയ സന്തോഷമുണ്ട്. നമ്മുടെ ക്രൈസ്റ്റ് കലാലയത്തിൻ്റെ തന്നെ MSc സ്റ്റുഡൻ്റാണ്. ശരിക്കും പറയുകയാണെങ്കിൽ ഷാഹിനയുടെ കൂടെ പഠിക്കാനുള്ള ഭാഗ്യം എനിക്ക് കിട്ടണമായിരുന്നു. കാരണം 2001 ഞാൻ എൻ്റെ ഡിഗ്രി പൂർത്തിയാക്കിയത്. അപ്പോൾ ആ കൊല്ലം തന്നെ ഷാഹിന SHA കോളേജ് ചാലക്കുടിയിലെ ഡിഗ്രി പഠിക്കുകയായിരുന്നു. അത് കഴിഞ്ഞ് ഇവിടെ വന്ന് ഷാഹിന ജോയിൻ ചെയ്തപ്പോൾ ഞാനിവിടെ പോവുകയാണ് ചെയ്തത്, ലയോളയിൽ പഠിക്കാനായിട്ട്. അപ്പോൾ ശരിക്കും പറഞ്ഞാൽ ഞങ്ങളുടെ ആ ബാച്ചിലുള്ള ജോസഫ് കല്ലൂക്കാരൻ ഇവരൊക്കെയായിട്ട്, അപ്പോൾ ജോസഫും ഞങ്ങളൊക്കെ ആയിട്ട് അതിനകത്ത് വളരെ ക്ലോസ് റിലേഷൻ ഉള്ളതാണ്. അപ്പോൾ ആ ഒരു രീതിയിൽ പറയുകയാണെങ്കിൽ നമുക്ക് അഭിമാനിക്കാം. തീർച്ചയായിട്ടും ഇന്ന് വലിയൊരു സ്ഥാനത്ത് ഷാഹിന ആയിരിക്കുന്നു. അതിൽ വി ആർ റിയലി പ്രൗഡ് ഓഫ് യു. ക്രൈസ്റ്റ് കോളേജ് ഈസ് റിയലി പ്രൗഡ് ഓഫ് യു ഫോർ ദ വണ്ടർഫുൾ അച്ചീവ്മെൻറ്റ്. ഞാൻ മനസ്സിലാക്കാനിടയായി നമ്മുടെ കലാലയത്തിൽ മാത്രമല്ല വേറെ ഒത്തിരിയേറെ കലാലയങ്ങളിലെ IP എക്സ്പേർട്ടായിട്ട് പാറ്റന്റ് എക്സ്പേർട്ടായിട്ട് അവർ ഷാഹിനെ നോമിനേറ്റ് ചെയ്തിട്ടുണ്ടും എന്ന് ഷാഹിന അതിൻ്റെ ഇടയിൽ എന്നോട് സജസ്റ്റ് ചെയ്യുകയുണ്ടായി. അപ്പോൾ ഈ ഒരു സായങ്കാലം ആശയങ്ങൾ നമ്മുടേതായി സൂക്ഷിക്കുന്നതിൻ്റെ അതിൻ്റെ പ്രാധാന്യത്തെക്കുറിച്ച് മനസ്സിലാക്കാനും പ്രക്രിയയെക്കുറിച്ച് മനസ്സിലാക്കാനും നമ്മുടെ തന്നെ വിദ്യാർത്ഥിയായി ഇന്ന് വലിയ നിലയിലെത്തിയിരിക്കുന്ന ഷാഹിന നമ്മളോട് സംസാരിക്കുന്നു. എല്ലാ നന്മകളും നേരുന്നു. ഫിസിക്സ് ഡിപ്പാർട്ട്മെന്റിനെ ഡോക്ടർ KY ഷാജി സാർ വൈസ് പ്രിൻസിപ്പളായ ഷാജി സാറിൻ്റെ നേതൃത്വത്തിൽ ഇങ്ങനെ നല്ലൊരു ടോക്ക് നമുക്ക് ഫിസിക്സ് ഡിപ്പാർട്ട്മെന്റ് നമുക്ക് അറേഞ്ച് ചെയ്യാൻ പറ്റിയതിനെ പ്രതി ഫിസിക്സ് ഡിപ്പാർട്ട്മെന്റ് ആത്മാർത്ഥമായിട്ട് ഞാൻ ഈ അവസരത്തിൽ അഭിനന്ദിക്കുന്നു. IQACക്ക് അഭിനന്ദനങ്ങൾ അർപ്പിച്ചുകൊണ്ട് എൻ്റെ വാക്കുകൾ നിർത്തുന്നു. താങ്ക് യു സോ മച്ച്.
Thank you, Father. Now we are about to start our talk, and I'm happy to invite Edwin Sir from Department of Physics to introduce our resource person of the day, Dr. Shahina Abdullah.
Good evening, all. It is my pleasure to introduce Dr. Shahina Abdullah, resource person of today's international webinar. Dr. Shahina completed her MSc Physics from our college in 2004. She joined as a junior research fellow at ISRO shortly after her MSc. At ISRO, she worked on a project in the development of AstroSat, which is the first multi-wavelength astronomy satellite by Indian Space Research Organization to involve in multi-band observations, and it was jointly developed with Indian Institute of Astrophysics, Bangalore during 2004 to 2006. Dr. Shahina completed her PhD in electrical engineering in 2011 from University of Twente, Netherlands, on the topic integration of micro cantilevers with photonic structures for mechano-optical wavelength selective devices. She continued as a postdoctoral researcher in the same institute. Later on, she joined as a patent attorney trainee at NLO, Hague, Netherlands. Currently, Dr. Shahina Abdullah is working as an IP consultant with Tatasteel Europe division at Netherlands. Thank you and welcome, Dr. Shahina.
Thank you.
Thank you, Edwin. And I welcome Dr. Shahina to take over the session.
Yeah, thank you very much for the kind introduction, and I'm very honored and very happy to give this presentation, especially to my teachers and also some of my juniors, I think. I'm very honored. I haven't prepared a very detailed presentation. I thought I'll just give a small introduction to introduce the subject, and then we will move on to some Q&A section. So then if you have some specific questions, then I can try to clarify them. I think I'll share the screen. Is it visible?
Yes, ma'am.
Yeah, yes.
Yeah, it's visible, right? Okay. So, this intellectual property rights or intellectual property is a very broad term. It's an umbrella term, and it comprises many things like copyright, trademark, patent, registered industrial designs and non-registered industrial designs, trade secret, plant variety, etc. People classify them as soft IP and hard IP, depending on how technical it is. So the copyrights and trademarks, it's not a strict classification, but they say copyrights and trademarks are, there's not much technical, but then it's more the legal aspect of it. But the patent is really a technical thing. So it's called a hard IP. So the whole presentation, I'll be focusing on the patent aspect of the IPR. So what is a patent? Patent is it's a legal right, actually. It's a legal right of something you invent. So when you get a grant of a patent, you get an exclusive right of that invention. And this grant will enable you to stop your competitors from commercially exploiting this invention. So it's a tool to stop others, not to mimic or copy your idea. And then this grant is for a limited period of time, and in a limited territory, depending on how you filed. So the period is usually 20 years. And then depending on the country you applied, you get a territorial effect in that country. And the patent can be, you can get a patent on different things. It can be a product, and it can be a process, and it can be a use of something. So for the product is the strongest patent. For example, if you make a sensor, for example, so when you patent the product, then you get the monopoly for the whole product. Actually, you get the right for the product. But sometimes the product is already there, but then you find a special method to make this. Maybe you find a method to manufacture it cheaply, and maybe you find a method to improve its efficiency, and then the product is already existing, but then you cannot patent the product, but then you patent the process of this novel process you achieved to manufacture. Then you get the patent only for the method and the product achieved by that method. And sometimes it happens that the product is already available to the public and the process is available. There's nothing new in that, but a specific use of it is in novel. For example, like you have a specific component, and then in a certain process, and when it is when you're using at a specific temperature, it has a different effect. So, and when you buy from the shop, this effect is not there, but when you use it, you get a specific effect. And in that case, the use of that, can be protected. So this is a basic thing about the patent. And patent is like an asset. Actually, it's like if you buy a house, then you get a right on the house, and then you get the right to sell it. You get the right to buy it. Maybe you can rent it or lease it to some people for a specific period of time, and you can pass this house to your successors, like your children or successors, or you can assign this patent to so patent is similar to that. It's a right, it's a legal right, and you can do all these things which I just mentioned if you get a granted patent. And you might think why people patent. For example, you can also publish, right? So when usually in academia, in universities or in colleges, when you find something during the research procedure, you immediately want to publish it. You want to go to a conference and publish it, or you want to exhibit it, or but why you want to do it in a different way by patenting? Because as I told now, patent gives an exclusive right, but it also gives a return of investment. For example, if a company is developing a vaccine, usually developing a vaccine is a tedious process. It takes several years, sometimes 7, 8, 10 years to make a new vaccine. And then you spend years, your resources, your people on this research project, and you want to get a return of investment of this research work in the coming years. So the patent enables you to have monopoly of this invention and to get a return of investment from the market. Another opportunity is to license or sell the invention. For example, you have a patent and you think that I don't want to use it to manufacture now, but maybe I can give it to some company. For example, if Christ College research department finds something, and obviously you are an academia and you won't be manufacturing a product, but what you will do is you'll file a patent, and when you get a grant, you can license it to some companies like entrepreneurs or SMEs. Then they can use this to manufacture, and then in return they gave you the monetary aspect of it. And some companies, like small companies, file patent because usually companies merge or do acquisition or these kind of things. So when they have patent, it's like a tangible asset of their invention, and then they it gives a very good negotiation power on them. So the value of the company increases depending on how many patents, good patents they have. So it gives a good negotiation power for them. And also it gives a good impression of the company, like that you are quite active in the field and you have taken care to protect it. So that's why generally people patent it. And to patent, actually, it should be new. So you cannot patent something which is already available. So I think you all know that. And even if it is new, and if you disclose to public, then it's also not possible to patent it. So the holy grail is the novelty and inventive step in the patent field. So the invention has to be new. So it's really should be new and should not be available in the public before filing it. And by inventive step, in the patent field, the novelty and inventive step are two different things. Novelty means it's absolutely new. And inventive step means if you combine two things, it's not easily achievable for a person in the art. For example, there is already a thing, A is existing and B is existing. And if you combine A plus B, it's a new thing. But if this combination of A plus B is a very easy process that normal person can think of it, then it is not patentable. But when you combine A plus B and then you get a very specific effect, and then it's not easily guessable, then it is arguably inventive. So for the inventive, there should be an inventive, there should be a technical effect. It should be solving a problem, a new problem. So there are certain criteria to be inventive. So, and then the third thing is that it should be possible to industrially manufacture it. So these are the three basic things that they check when you submit an application to patent, that it should be novel, it should be inventive, and it should be possible to manufacture industrially. I was talking about prior art before. So prior art means everything that is available in public before. So for example, if I'm going to submit an invention today to the patent office, everything available to public until yesterday is called prior art. And everything, if I file successfully today, everything which is, if another person discloses it tomorrow, then it doesn't form prior art. So the filing date is very important. That decides what is prior art and what is not prior art. And this prior art can be anything. It can be an oral disclosure between two persons. It can be a lecture. It can be a speech. It can be a demonstration in an exhibition, and this can be in any language. For example, in Christ College, you find something and you want to file it today. But if someone disclosed the same invention in Chinese language in China in a very local newspaper, that still forms the prior art. How you find it, that's a different question, but legally that is still a prior art. And if you are going to file an invention today, and for example, two persons talked about it maybe in a train in Russia, which is an oral disclosure, and if there is an evidence for that, that still be prior art. So it's very important not to disclose your invention if you think you are going to patent it. It has to be very careful. Even if you want to disclose, it should be with a non-disclosure agreement, then it is not possible. Then it is okay. So every time you want to disclose it to somewhere, it should be under the non-disclosure agreement. And if you are going to present it to a conference or an exhibition or something, make sure that you file it before that disclosure date. So that's one thing very important in the patenting procedure. And as I just told, the patents are territorial effects, and it's granted in specific territories. For example, country-wise, region-wise, or maybe internationally. Yeah, but international applications still enter a national phase. So then by national application, I mean in specific countries. For example, you get a patent in India. So then you have the right to stop someone only in India. And if you get a patent in India and someone manufacture the same thing in China or in Japan, you cannot stop them. You can only stop someone doing in India. And there are also regional patents, like in EPO, that's a European Union, or Veepo, for example, the African region or Eurasian region. So there are also regional application. And if you get a grant there, it's a single procedure there, and then you get a protection in the whole region, which is contracted to that regional agreement. So that's one way of getting a patent. And there's also international application, which is called PCT, Patent Cooperation Treaty. It's a bit expensive, but it's the important thing is that, for example, if you make an invention, like you found a new method to have a highly efficient solar cell, and if you want to patent it in like many countries, like in India, China, Japan, or America, like you want to patent it in 50 countries, it's quite tedious process to go to do each country because it's also expensive, and it also depends many procedure. So this patent in PCT is like a one procedure. You apply in an international application, and then it has one procedure, and after the grant, then it enter to different countries you want. So the international application has, for 13 months, it has one process, and then after that, then it enters into regional countries. So whole this 30 months, which is like a 3-year time, you have also time to think which countries you want to enter. When you file, you already get the filing date. So your idea is you get the priority date on that day, on the filing date, but you still get some time to think which countries to enter. For example, initially when you filed, you thought that I want to patent it in 50 countries, but maybe after 3.5 years, you understood that your business is not interested to continue in all these 50 countries. I only want to go to 10. Then after the 3, you still get the time to think, and you only want to go in the 10 countries which you chose. So that's the convenience of doing an international application. I can just explain how it's pretty much similar in all the countries with slight differences in procedure, but pretty much it's a very similar process. So I will just say how it is in Europe. You have an invention, and then what you do is you draft the application with a very good description and claims. Claims are the backbone of the patent. So you have this invention and you file it in the office, and then the patent office will do a very good search to confirm that it's really novel and inventive. So they do the search, and then they also publish in between, and then it enters the examination procedure. In the examination procedure, the examiner will thoroughly check it, and then maybe he will find a document in another country, and then he will say, hey, this patent, the part of this invention is already there. So we don't think it's patentable because we don't think it's new. And then you carefully look into this, and then you find maybe some difference, and then you argue back. No, this is, I think your conclusion is different because of these reasons. It's still valid, and then you argue back. And sometimes the examiner is right, and then you kind of amend to reduce the scope so that it's not, you're not in the scope of the existing document. So this iteration procedure continues for several times. You get one communication, then you reply to that, and then maybe you get again and again. So after 3-4 times, you kind of reach in an agreement. And if that doesn't happen in 3-4 iterations, then you have an oral proceeding where you go in person to discuss with the examiner. You have your arguments presented, and they also have their arguments presented, and you kind of see where you can converge or maybe it's not even able to patent it. So after that, they take a decision whether to continue or not, depending on your arguments. And then then they decide to either grant or reject it. After the grant, you get the patent granted, but that still doesn't mean that the whole procedure is over. Once it is granted, your competitors come to know that you got this patent, and then they're going to check whether your patent is going to be a threat for them, or your patent is going to, patent is also like what's that, merging with their inventions, or are you stepping into their area? So they try to stop you by entering into an opposition procedure. So what they do is they try to either kill the patent or try to reduce the scope of it. So they enter the opposition. They have 9 months time after the grant to do this opposition procedure. And then after the opposition procedure is the same as I just told in examination. You have again this kind of argumentation sections, all proceedings, and then maybe after the end of the opposition procedure, the patent is killed by the competitor, or maybe it is maintained as it is, or maybe it is amended to a smaller, narrower scope. And after that, if you are not happy with the opposition procedure, you can still appeal, and then it continues. So this is a basic procedure that happens in the patent office. Yeah, so this is a picture of the international application. This is a picture of the map of the countries that have all the blue countries have a contract with the PCT. So if you do an international application, you are entering in all these regions, and then you can choose at the end of the 30-month period which countries you want to choose. There are some countries which are in the gray that are not contracted to PCT. So if you want a specific patent in that countries, then you have to do it in a special application to that specific country, like in Argentina or some African countries, and also in Asia, like Thailand is an important country. So yeah, those are the countries who doesn't still have a contract with the PCT. Application typically has a request asking that I need this patent, and then you have a description, which is a highly technical document written in a legal language, explaining how this invention can be executed, and one or more claims, typically 15 or 20 claims, but at least one. And these claims define the legal scope of the patent. So that's very important. And then you typically have drawings as required, and abstract. So this is how a typical application looks like. Yeah, just put some pictures of how such report looks like. That's not very important, I think. And I just want to say how you want to look for a patent. For example, there are a lot of free applications where you can find the existing patent. So if you want, if you find something and you want to know whether it's already existing, and if you want to do a quick search yourself, these are some of the websites you can check. It's freely accessible. Espasnet, that is from the European Patent Office. It looks like this. Actually, it's freely accessible. You have it in English, and then you enter the keywords here, title or publication number or something, and then you do a search, and then you get all the documents in that field, and then you can check a freedom, whether you have a freedom to operate from those applications. So, and similarly, the US Patent Office, USPTO, also has a website, USPTO website. You can check that, and you can also access a lot of US patents there. And then the World Intellectual Property Organization has a patent scope website. You can also check there. And Google also has like Google patents. So you can just go to Google patents and search a title, and then do a quick search there. So these are the ways you can see how to see what's going on in your field. So I was talking about the World Intellectual Property Organization. That is like one of the organ of the United Nations. Its headquarters in Geneva, Switzerland, and they act as a spider in the web. I mean, they act as a coordinator to coordinate all this international application procedure within all the contracting states. Like Veepo has something like 153 contracting states. So they do all the coordination of the international procedure. I just want to add, if you want to know more about how the patenting is beyond this talk, you can also go to the Veepo website. They have an e-learning center. Some of the courses are also free there, so you can try to attend. It's a remote distant learning program. They have an academy called Veepo Academy, and they also sometimes offer summer schools, but I think for a specific group of people. So yeah, so you can just check the Veepo website and see whether you want to attend some basic courses. Like I usually suggest this course, general course on intellectual property. They schedule it like 2 times a year. You can attend it, and then it's like distant learning, and then at the end you have like an online test and you get maybe a certification or something. So I think that's something interesting to do if you want to further pursue in this field. Yeah, and about this profession, I'm a patent attorney in Tatasteel. So Tatasteel, it's an Indian company. It's a Tatasteel, but they also have a in UK and in Netherlands. They also have their European branch. So I am doing only for the European applications. We are a small department of like 10 people handling all the European procedures. And I think they also have something in India for the Indian procedures. Patent examiner, I just explained, it's examiner in the patent office. Their main duty is to examine and see whether the applications they receive are novel and inventive. That's their main task. And patent attorneys are representing the other side for the client. We do the drafting, we do the drafting and filing, and then we do the prosecution, which means this communication with the examiner, negotiation with the examiner. And then we also do the opposition procedure, application procedure. So these are the main tasks of a patent attorney. In some countries, the patent attorneys are also called as patent agents, patent engineers. They also do similar stuff, but a patent attorney is more of a qualified position where you have a license, like a bar license, like a legal license. But the agents and engineers are, I think it's a different title. And to support the attorneys, you also have like paralegal sessions, like formality officers. They help in finding the exact deadline. They help in arranging the translation, and they take care of all the bureaucratic aspects. So this is mainly the people who are active in this profession. A typical day of an attorney in my practice, I can explain, because I first did in a law firm, with a private law firm, and now I am doing in a company. So I can explain how it's different in both the aspects. So in a typical law firm, what happens is you do patent work for any of the companies that approach you. For example, one day maybe Philips is coming with a specific biosensor, then you are working on that for 2-3 days. And the next day you get like from Shell, they have a specific coating to apply on a pipeline, then you work on that. And the next day you are getting like a specific bottle and an opener for a shampoo bottle from Unilever, then you are working on that invention. And the 4th day you're getting like how to charge an electrical car, then you're working. So it's quite diverse depending on what cases you get from different clients you have. You are doing like working on that. So I liked it because it's quite variety of work. Like every day it's different. It's basically physics, but then every day it's a different new invention, and then I'm working on that, and you get this, you are becoming a generalist in the field. That I did that for 4-5 years, and then I was thinking like I want to focus on one specific field, and that's why I moved to industry. So in Tatasteel, I'm mostly taking care of all their invention, the portfolio of the steel coatings for automobile applications. So basically the coatings, different type of coatings they do for cars. That's what my expertise is. So it's a very technical document. So basically the argument are like this. For example, our coating has this much of zinc concentration, and because of this, the tensile strength is in this range, and this gives a very high formability to the steel, which is not new. Or maybe it's like we are like found a very specific steel composition having this certain range of alloy, and this gives a welding and formability in a specific range. So it's the arguments are typically quite technical, but then you do the arguments with the help of the legal language. So I like the job because it's highly technical. At the same time, you need to use your verbal skills. I like this verbal aspect of it, of arguing and negotiating, and like linguistic skills are very important because you have to be linguistically good to argue. Yeah, it's basically how a lawyer is doing. Yeah, so this combination, I like it very much, because when I was a scientist before, I was only doing technical thing, but this has a different dimension to the work where you also need other skills. And you also need to know the business very good. Like if you have a patent which is not useful for the business, and you spend all this money, but if it's just sitting on the shelf, it's not useful for the company. So you want to look at how, in which direction the business is going, and then you want to steer your, means you want to protect inventions which are in the direction where the business is progressing. So that's also understanding the technology, the legal side, and also how the business of the company is. And it's also quite a people interacting job, because you have to talk to the inventors and understand what they're talking. They are specialists in the field, but you have to comprehend what they're talking quite, you have to understand how, when they explain quite fast, and then understand it, and then yeah, make your arguments. Yeah, so these are the skills you require for this job. And I like it because I think it's also matching with my personality, so I like it. Yeah, so that's what it is. Yeah, that's it. So I just stop here, and I think I will now look for questions. So I'll stop it now. Yeah.
Okay, thank you so much, ma'am, for a wonderful and very informative session. Now we can have an open discussion session, and I welcome all our respected participants for the open discussion.
ഷാഹിന, എനിക്കറിയാനുള്ളത് ചെറിയ ചെറിയ കാര്യങ്ങളാണ്. അപ്പൊ ആദ്യം റിസർച്ചിന്റെ ആൾക്കാരുണ്ടെങ്കിൽ അവരുടെ ഡൗട്ട്സ് ആദ്യം ആയിക്കോട്ടെ. എനിക്ക് ഈ കൊക്കക്കോളയുടെ ഫോർമുലയും അങ്ങനത്തെ പഴയ ഹിസ്റ്ററി കാര്യങ്ങളൊക്കെയാണ് എനിക്ക് അറിയേണ്ടത്. അതുപോലെ ബുക്ക് റൈറ്റിങ്ങിന്റെ ഇഷ്യൂസ് ഒക്കെ. റിസർച്ച് സ്കോളർ ഗൈഡ്മാരുടെ ഡിസ്കഷൻ ആദ്യം ചെയ്യാൻ തോന്നുന്നു.
Shahina, one question. Once we publish a paper, then can we go for a patent? Or...
Yeah, that's a very good question. Yeah, it depends again on the country. Some countries it's really forbidden. If it's disclosed, then that's it. It's the end of the day. For example, in Europe, it's not possible. But there are certain countries, they have given some grace periods. For example, in US, you have a 1-year grace period. And in Japan and Australia, you have like a 6-month grace period. So these countries, even if it is you published, you can still patent the same invention. But for example, I don't think in India or in European countries or some other countries, it's not allowed. This is a very special exceptions they have. So I would say be careful before if you intend to patent, be very careful and yeah, careful with that. Does that answer the question?
I think yes. Do not publish any paper if you want to patent it. Is that?
Yeah, or file it before, file it, and then when you get the filing date, then it is like it's like written on the stone. So you get the filing date, and then after that you can publish it. You don't need a grant, you just need the filing date.
Okay, what about data? Means I found that all the astronomical data is published after 5 years.
Mm-hmm.
It is only incubation period is only for 5 years, and after that all the data, astro data, is published on the web. Is there there any rule like that, or they are simply doing it for encouraging people?
Yeah, actually, this comes in a this is a quite emerging field in patent. It's called computer implemented inventions. All these data related and software related stuffs, because it's in the patenting field is a quite traditional thing, and this is like a new thing which happened after like 90s and something. So the data itself is not patentable. But then if you find like a specific algorithm, or if there is a technical effect from this pattern, from this data, and if you can demonstrate that, okay, and if you find an automation method, then that specific technical, it has to be technical. So just a mathematical equation or some mathematical numbers, you cannot. But if you find a technical effect from these numbers, which is not existing, that is patentable. In Europe, it's quite strict. They are very strict with the computer implemented inventions, and the technical effect is it's very required. But on the other hand, in US, for example, they are a bit more lenient. There you can still publish they're a bit more lenient, but it still has to be technical, like a business method or something. It's still possible in US, but then it's only you get only protection in US. Yeah, so basically data alone and equations alone won't be possible to patent. You need to get a new technical effect.
Okay, thank you.
Hi, Shahina. This is Babu is calling from Eindhoven. I was invited to this talk by my friend Robinson. So thank you for the good discussion on the IP and its relevance for research. My question is, working in a multinational company, usually we put quite some effort and resources for protecting IP and to have a good, strong IP portfolio. That makes sense. But if you talk from a perspective of private research institution, or for example, universities or academia, what would be your advice? To what extent they should put effort? Because there are lots of great inventions happening in fundamental research in universities, research institutes, etc. What would be your advice? Depending on how much money and effort that we need to pay. For example, if you want to file a global patent, it costs around 30 to 40 lakhs Indian rupee. Yeah. So what would be your advice? What is the bottleneck there?
I think in this case, if it's only required, if you have a business requirement, then only it's required to patent it. For example, if you have even if it's a very beautiful invention, but if it doesn't have a business application, or if there is not an immediate requirement, as Babu said, there is no point in spending a lot of money and then just keeping it on shelf. So you need to see whether there is a company or if there is a potential that it's going to enter into to the market, then it's worth doing all this tedious process and spending a lot of money. But if it is just to patent it for the sake of patent, that's not advised. I would say that.
Okay, good. So your advice would be to check or do a sort of sanity check with the business partners
Exactly.
to get their background, to get their feedback on the business relevance, and then decide to file. And that process has to happen before you start publishing it, right?
Yeah, exactly.
Thanks.
Yeah.
Thanks, Shahina.
Thank you.
I have got one more question. I have read that many of our Ayurvedic knowledge have been patented by people or companies from the Europe. Is it right? I have read something like that. Or what would be the, I would say, the repercussions of it, the implications of it? Some of the Ayurvedic knowledge which we have.
Yeah, I think, for example, the famous case was about this turmeric. For example, turmeric alone cannot be patented, but then they are finding, for example, if it's finding a method to extract a specific thing to treat a cancer from turmeric, then that's what they're patenting. But then the material alone itself is not patented. So they are only doing like a specific method to extract from that, or like combining things, or a method of making it. So those kind of things are being patented. But again, yeah, if it is already existing here, and if there is an evidence for that, it's still possible to to oppose it, I would say. If we can prove that it's a prior art which is existing of what they have filed, and if you can provide the evidence, it's still possible to stop it. That's what I think.
Hi, can I ask a question? This is Dr. Soni from the Department of BP, Christ College. In certain countries, we find that two types of patents, like one is a standard patent and the other one is an innovation patent. Is it the same way in all countries, or is it, because I saw this one with Australian Patent Agency, actually they have two kinds of patents. And I find that the innovation patent is just for a shorter period, like 8 years, whereas the standard patent is for about 25 years. So is it the same way in all the countries, or is it that some countries have that kind of a process?
Yeah, I think it's a country dependent. For example, I can explain it in, I don't know about the Australian one, but I know that in China, for example, they have patent, which is like what I explained now. It's a patent, and then they have something called utility model, which is like it's for shorter period of time. The examination is a bit lesser. It's a different procedure, and you get the grant quite fast. So if someone wants a very quick and dirty protection, not as extensive as a patent, they go for utility models. And the difference is that utility model are only for products. You cannot do it for methods. It's only for products, and then it's for a specific period of time. And the protection, I think the scope is also not that exclusive, but it's faster. Sometimes you need that. For example, if you want it, because this process, the granting process is quite extensive, and maybe you want it like a very fast protection because you kind of came to know that your competitor is going to expand in this area and you want to stop them, but you want something before a specific period, then they go for this utility model. I know in Germany they have it, and in Spain they have it, in Japan, in China. Yeah, so there are some countries they have it, not in India. And I think it's the same thing you're talking in Australia also.
Yeah, they have. I know that they have an innovation patent program as well as standard patent program. They have two kinds of patents here. Right. Thank you. Thanks for.
Any more questions?
Yes, I have one question. Hello.
Yes.
Okay. I am Dr. V.T. Joy, Department of Chemistry. Suppose I file a patent. Patent office publish it after some time. Then there is a delay in granting the patent. During this interval, before granting the patent, someone in a company reads the patent application and starts to use my process. So is it possible to prevent that company using that process?
Yeah. Yeah. So when you file a patent, if you get it granted, the protection starts from the date of filing. So if they're starting to infringe after your filing date, then definitely you can. But you can exclusively do it after the grant procedure only. So when you file a patent, after a certain period, it gets published and you get a provisional protection, which is like, you get a provisional. The provisional protection is something like, it's like treated as if it is granted, and then you can stop them with that. But once it happens that this patent is killed later, then your provisional protection also stops. So it's one of the strategies the companies do. They file it and they make sure that it's published faster by doing some bureaucratic adjustments, and then you get the provisional protection and use this provisional protection as a tool to stop others. And then once it is granted, then it becomes a full protection. So that's one way of doing it.
Can we claim any kind of compensation for using our process in this period before granting the patent?
Yeah, if your path is clear, then people ask for compensation. For example, companies in the US, they are quite aggressive, and some companies are quite aggressive, and they ask for a lot of compensation and thing. But it's also like you have to be careful, and if it is not the case, and if you are damaging the reputation of the company, then they ask again a written compensation, which can be backfiring also. So it has to be careful process, and it has to be done after careful checking, because if you are doing something which is not a truth, and then it's going to backfire you. Yeah, I would advise then you need a legal person, not an attorney, because attorneys are technical persons with a specific legal knowledge. But in those kind of cases, you need a proper lawyer.
Okay, yeah. Thank you.
Shahina, one more question. Yeah. I think you can also speak something about the copyrights of while writing books or theses. So lot of plagiarism checking like that. I think you can speak something about. We know a little bit, but we want to hear from an expert.
Actually, it's not my field. Actually, I'm really specializing only in patent. To be frank, it's not my field, so I don't want to say something wrong. Yeah, but as I know, the copyright is for, I think if you publish it, you get the copyright, and it's for 70 years or something. To be frank, and it's also territorial dependent, and it's different for different countries. And I haven't done much on that. So yeah, if it's patent, then I would answer.
Okay. So one more question is that in my younger days, I heard about the formula about the CocaCola, and CocaCola when came in India, I think in some 20 years ago, only CocaCola came to India. It was not at all so much tasty, but some mystery was there always. Is still it is patented, the formula of CocaCola? They claim that something is special with that formula, like that. Is there any still? It is periodically. You said it is only for 20 years or something like that. After that, is that patent is over?
Just one moment, I will come back. Yeah. Sorry, I had to close the door for a moment. Yeah, for the Coca-Cola, I think they didn't patent it, but they kept it as a trade secret. So there is a risk in that in keeping it as a trade secret, that Yeah, it has to be exclusively kept within the company. Otherwise, yeah, it has to be kept as a secret within the company, and they should take care that it's not leaked. So you cannot keep like that, but there is a risk in that. As far as I know, they didn't patent it. It's just a combination of a taste. They kind of kept it as a secret. That's what I can comment on that now.
Okay. So that yes, that they say claim it as a secret.
Yeah, it's a soft IP. It's called trade secret. So it's not patented, but they kept it as a trade secret. Like a trademark and copyright, there is also another category of IP called trade secret. So yeah, I think they went in that direction. That's what, as far as I remember, that's what happened.
Okay, thank you.
Can I ask you something? Why do they want to keep it just as a trade secret? Why don't they get it patented? Is there something really mysterious behind it? They don't want to reveal it to a patenting agency or something of that sort?
Yeah, the thing is, if you patent it, you also get the exclusive right for a specific period of time, but that also means that you need to disclose to the public so that they can reproduce it. And then this exclusive right is for a very limited period of time, like 20 years. And after that, anyone is free to copy it or make it, and then they cannot stop them. But if you keep it as a trade secret, then you can keep it for as many years as you want. And yeah, then it's within, then it's not available to the public anymore to copy it. For example, if Coca-Cola has kind of protected it in some manner, which means that after a specific period of time, it's available to the public and anyone can make it. But because they kept it as a trade secret, it's still not available to the public. So some people do that for that aspect.
Right.
Yeah.
Thank you.
Ma'am, I'm Andrews. The talk was very good, and I have one doubt. Can you explain about the patenting authority? Once we have published the one patent in one of our journal or something patent is filed, then why it is called for some US patent or something like that? Or it is after once we have published in India, then we have waiting for a US patenting or something like that. I don't know. Can you please explain something?
Yeah, that's because if you do it in India, you get only right in India. So maybe some people want protection in different countries. So if you get in India, that doesn't mean that you can stop your competitor in US. For US, you need a patent in US. So what people do is they, as I explained in the PCT procedure, they apply in many countries and then they choose after this period, 30 months, they choose the countries where they want to enter. So for example, in this case, which you just mentioned, they might have entered in India. So then you have a national procedure in India. And then in a similar manner, they might have entered also in US, where you have a national procedure in US, which means that you need to get a grant in India at the end. And also you need to get a grant in US to have an effect in these two different territories. So the international process is facilitating the process initially and after a period. And then if you get a very positive result from the international process, it speeds up the national process also. So if it is like declared in the international process that is novel and inventive, then the national procedure becomes easier. I don't say that in all cases, but mostly then it becomes easier to convince the national examiners. Does that answer the question, or was it the different?
Okay. I have also one doubt. When I was doing some in research, I heard that the people are doing some research and they find out some inventions. And while we are publishing a patent, we have the students get only only the patenting authority is the guide, and while the student is something co-investigator or something like that, or any certain inventors are there. The corresponding author or the supervisor got the correct inventor of that invention something.
Yeah, actually, in patent, it's like everyone who is like an applicant get the right, but then it depends on the contract you have with them. For example, in certain companies, when you have an employment contract with them, you sign that all the IP generated in this program are part of the company, and then even if you find using their resources and their project, even if you are the inventor or applicant, the company holds the patent. So all the other rights, other than being mentioned as an inventor, everything goes to the company. So it depends on the countries also. For example, in Netherlands, it's in the employment contract and it's for the employer. But then there are in certain countries where the inventor also has some rights. I know, for example, I think in France or maybe in some Middle East countries. So it depends on what kind of contract you have with your employer and with the project owner. So if it is defined in the employment contract or the contract that the IP is owned by the contractor or it's mutual, then it's depending on that. So yeah, so some cases they are like it's shared, then it means that you both share the IP rights once it is granted. So it depends on what kind of contract you make before applying with each other. And usually if it is an employment, that is defined in the employment contract. And if it is like you're doing a partnership or collaboration with different companies, then it's also well defined before the collaboration starts, like how the IP will be shared or owned. So that part is also taken care when you sign the contracts before. Usually that's done in that manner. Yeah.
Thank you. Thank you, ma'am.
Any more questions?
Shahina, I have one more, G.
Yeah.
Okay, sir.
Recently, one of my friend approached me. He was working in an R&D firm, and he's now going out from there. So he want my help actually, and he told me you can work part time, and my job will be to go through the patents and find the loopholes. So I told him, let me think about it. So what he was explaining me is that you should go through the patents, that is about some food industry. You have to go through the patents and find the loopholes, and then we will make a process according to that. Actually, this type of research or data mining, is it legal? Any idea about that, Shahina?
I think it's okay to do, but if they have a specific business requirement for that, yeah, they do that. I think in specifically in the pharmaceutical industry and all, they are quite looking at when the generic patents are expiring, and then they are like looking what are the possible, not the generic, I mean the actual patent is expiring. The generic companies look into how it's possible to make it in a generic way, and then they do that. So I don't think it's illegal, but if that should be a business requirement for that, just for the sake of finding loophole and patenting, I think it's not fun, because it's quite expensive to do that. But if it's really required, then I don't think it's illegal. This is called also freedom to operate, actually. So when you get a patent, you look at the claim, and then you look how much is the scope, and then you see whether your intended product is going to infringe or enter into their scope. If it is entering their scope, then they can stop you. But then you look at possibilities that you're not infringing them, so that you have the freedom to operate. That's what usually companies looked at, whether you have a freedom to operate. So you look at the competitor's patent, and then you look where you have the freedom, and then they kind of file it in that manner. For example, if a patent says that we have a steel of this range of carbon from 0.5% to 1%, and then maybe you can look into a different range if that's your requirement. So that kind of things they do, they look and do, where you have the freedom, whether you are stepping into their scope, something like that.
Oh,
yeah.
Thank you. Adding to what Shahina said, I think that's a normal, usual process in industries, because before we start thinking of a project or a product in the roadmap, the first thing that we need to do is that whether we have the right to play in the market or the freedom to operate. And one of the things that we do normally is to do the patent landscape analysis, meaning what our competitors are doing, which technologies are used. And then we have to make an assessment whether we have the right to do or to bring this technology to the market. If not, can we find some alternate ways or some specific parameter window that is not being claimed by prior art? And then we look for that one. So it's a normal process. There is nothing wrong in that one. It's quite genuine. It's general, normal process.
Yeah. Thank you.
Thank you, Babu.
So one more question. What will be the average expense for filing international patent? Is it the same for all type of inventions? Average cost?
I don't remember from by heart, but it's quite expensive. Like as Babu mentioned, like it can be 20 lakhs or something. And it's mostly the attorney fee actually. So there is application fee, which is like few lakhs. And then there is also, you have to pay for the attorney also for their hourly rate. That's also, so it's also the time of the attorney you pay. And if you are entering in different countries, like in France, you have to translate to French. And if you are going to China, you have to, so the translation is a thing. And then you also, after this granting, and after a specific period, then you have to pay like the renewal fees. That's also adds up. So for each country to maintain the patent for the 20 years, you need to pay renewal fees. And if you don't pay the renewal fees, then the patent will be deemed withdrawn. So the renewal fees also every year you have to pay a specific amount. So everything adds up into a big amount. So that's why it's quite expensive. So you do it if you think that your business really requires it. Otherwise, it's, yeah, because in our company, in Tatasteel, we do the harvesting, and then we look at the landscape, and then after that, okay, this invention need to be patented, and this one, no, we can just publish it, because then we publish it, and so that it's prior art and the competitor cannot patent it anymore. So sometimes you also advise your client not to patent it and just publish it. That's also the advice I give. So it's also always patenting. It's also looking at the business and their where they're heading to advise also not to patent. That's also an advice.
Okay, nice. Thank you. Thank you.
Yeah.
So,
Jean, I think we can wind up.
Yes, sir.
Almost.
I hope no more questions. So thank you, Shahina ma'am, and thank you all for such an active session. And now let me invite Dr. Robinson P. Palminishiri, our IQAC coordinator, Christ College, Irinjalakuda, for delivering vote of thanks.
Thank you, Jean. Respected principal of the college, Dr. Jolie Andrews, today's resource person, Dr. Shahina, Vice Principal, Dr. Shaju KY, and my dear participants. During the last 1 hour, we were going through all the intricacies and the complexities of patent filing and the associated processes. Dr. Shahina we had a wonderful presentation on IPR. Not only that, she also detailed on the opportunities existing as a patent attorney that may be interesting to our PG students. On behalf of all present here, I express my sincere gratitude to Dr. Shahina, who is also our valuable alumni. And indeed, it is my pleasure to thank our principal, Father Jolie Andrews, Vice Principal Dr. Shaju KY, for being with us. And also my sincere thanks to Dr. Edwin and also to Professor Jean Maria for the technical expertise. Dear participants, thank you for your presence and an active discussion also. Thank you all.
Thank you, sir. So that's the end of our program. Once again, thanking you all for your valuable and active cooperation throughout. Thank you.
Thank you very much all for listening and giving me this opportunity again.
Thank you, Shahina.
Yes.
Babu was one of your senior. Babu, yeah, from Babu is Holland.
Yeah,
From
he is
Holland,
also in Netherlands. Yeah, he was the.
Okay.
Yeah.
Yeah.
He
each
also
other.
did masters in Christ College.
He was the first
MSc
batch student.
We know each
First
other.
batch student.
Shaju sir, we know each other.
Okay. Oh.
He's my friend, and her husband is also my friend. So, so
Nice.
I was invited by Robinson to join the meeting, saying that your friend is talking, so please join. So I was in the with the kids in the park, and I had to step back. So good.
Oh, nice.
It's also nice to give the industrial aspects, explaining the industrial aspect of it.
Yeah. It was very nice. Nice talk.
Happy to see you all.
Thank you.
Yes.
Thank you, Shahina, once again. Thank you.
Thank you for the.
Thank you, Shahina. Thank you.
Thank you.
Thank you.
Thanks, everyone.
Shahina, very good talk.
Thank you, Joseph sir.
Happy to see you again.
Good to see you, Joseph sir.
Also, Babu is there, na?
Yeah.
Happy to see you again.
Yeah, happy to see you. I saw you in the participants list.
Andrew sir ഉണ്ടായിരുന്നു പോയോ?
And sir ഉണ്ടായിരുന്നു.
Nityanand sir ഉണ്ടായിരുന്നു, Xavier sir ഉണ്ടായിരുന്നു.
Okay.
ഷാഹിനയുടെ മൗത്തിൽ നിന്ന് ഫിസിക്സ് അല്ലാതെ കേൾക്കുമ്പോൾ